Welcome back to the Probate Nation, especially our returning viewers from the great state of Arizona. My name is Richard Ruddy. Tonight we are going to learn how Arizona assets owned by a deceased person who lived in another state are probated. This process is referred to as ancillary probate. Probate is very much like traveling on a slow-moving steam engine train from years ago, which calls to mind that story about the Supreme Court Justice Oliver Wendell Holmes, who was approached by the conductor seeking to confirm people's passenger tickets. Justice Holmes apparently couldn't find this ticket, and the conductor said it's not a problem, but the justice dissented. He said, look, I bought a ticket, but I need to know where I am going. So we're fortunate to have back with us Allison Kierman, an Arizona probate attorney who knows all about ancillary probate. She will share critical steps to be addressed and stops to be made in the course of any Arizona ancillary probate journey. But first, let me tell you a little bit about Allison. Allison is the managing partner of Kierman Law PLC based in Scottsdale, Arizona. She's actively involved in many charitable organizations and community activities, and she practices primarily in estate planning, probate, and estate administration. Welcome, Allison, and thanks again so much for coming back to share time with us and the Probate Nation across the country. So before we jump into ancillary probate discussion, we've talked about this before. With all the YouTube videos out there on just about every topic under the sun, many folks like to do things themselves, and we certainly applaud that. But is Arizona ancillary probate something a person can do on their own, what we call pro se, without an attorney?
Under the statutes, an attorney is not required to submit paperwork in Arizona probate court. However, I have found no pro se individual who's been able to understand the ancillary probate proceedings sufficiently to do it by themselves.
Well, that's important. I think the big thing for folks to take away as we walk through this program tonight is just some of the things to be aware of, and we'll come back to the importance about at least getting some guidance from an attorney at the outset. So let's talk a little bit about what is ancillary probate.
Ancillary probate is the Arizona simplified proceeding where you already have a full probate case opened in another state, and then you're just domesticating that to handle what is usually one or two smaller assets.
And what assets typically need to be probated in Arizona by a non-resident decedent estate?
We're mostly talking about real estate, a condo, a house, land, or even a mobile home.
Okay. And who needs to undertake ancillary probate in Arizona?
It's anyone where the deceased passed away owning Arizona real estate.
Okay. So and let's talk a little bit then about how we go about. So what's filed with the court or with the probate office to initiate an ancillary probate?
So you need all the same cover sheets and information pages as any other probate. So information about both the deceased and the personal representative. Then you submit what's called a proof of authority. So the court paperwork from the originating state that says this has been approved for probate, appointing a personal representative, and either waiving or approving a bond. And the third thing you need is called a deed of distribution, which is the deed transferring the property from the original deceased to the personal representative.
So the actual deed to transfer the assets is submitted with the paperwork?
It is.
Okay. Now, I know you just said that if the bond was waived in the probate proceeding in the other jurisdiction, then no bond will be required in Arizona. Is that correct?
That is correct.
Okay. And so what is the effect of this particular, does an Arizona attorney, this comes up a lot of times, does an Arizona attorney need to be listed to receive service of process while this ancillary probate is going on?
An attorney is not needed. The only one that receives service of process is actually the personal representative.
And that person can be someone who's not a resident of Arizona? That
is correct.
Okay. Are there different options available to probate in a state when a will is admitted in another state? Is there different ancillary probates?
There's not. There's just one ancillary probate proceeding type in Arizona, and that is, again, where papers, orders, and letters have already been issued by another state.
And the document you're looking for there is going to be what we call the triple seal, certified by the jurisdiction where the original probate proceedings were undertaken. Is that correct?
Yes, it is.
Okay. So the most common piece of most common asset we have to probate, of course, is real estate. So what's the impact of making those filings on the real estate that might need to be probated in Arizona?
So really, it's the only way that you can sell or do a transfer of title. So if you want to sell the property, the title company, before you ever get to the end, is going to need proof that you have the authority to have the sale. So they need letters originated by the original court, but they also need them to be domesticated through the ancillary proceeding.
Okay. Well, Allison, let's go ahead and move on to kind of talk a little bit specifically about what I think is the typical asset, as we mentioned, which is a condo or a new house down there, a vacation home down in Arizona. So someone has fully funded their home state assets, so there's no home state probate, but they failed to fund some or all of the Arizona assets. If there's no home state probate, how does that change what is filed in this process to proceed with ancillary probate?
If there's no home state probate, you cannot use the ancillary probate proceeding. You're going directly to the Arizona informal or formal probate process.
Okay. And once the ancillary probate process has been started, okay, and let's just say we do have a home state probate, what can we do? Once we've done that, what powers do we have at that point?
So the only powers that you have are to transfer or liquidate the Arizona assets. Okay. Arizona ancillary proceedings are usually a super short time frame. We're talking, it could be 3 weeks from beginning to end.
Wow. That's quick. That's quick. Well, let's talk about the duties of just because I don't want to overlook that. What are the duties of an ancillary administrator? What do they have to do in order to fulfill their obligations?
The only thing they have to do is transfer or liquidate the Arizona property. They don't have to file anything else or provide any other notices.
That's fantastic. No inventory, no accounting. And how about creditors? Do they have to do anything with any notices to creditors?
They don't have to do anything.
Okay. You emphasize they don't need to do anything. I'm sorry. How do we wrap up an ancillary probate? Is there any particular steps we have to take?
There's not even a closing of the ancillary probate. It really is just beginning to end. You file your paperwork, the court approves it, it gets recorded with the county, it's over.
Fantastic. That's really good. Let's talk a little bit about how people in other states who own property in Arizona, how can they plan to avoid having to go through an ancillary probate?
You really have two choices. Either you're putting the Arizona asset in a trust. It doesn't have to be an Arizona trust, but some sort of trust. Or you do what's called a beneficiary deed, which says this is who inherits the property when I pass.
Okay. What is the typical cost? And I mean, I know I'm not asking for what your fees are, but what the typical cost have you seen in order to take care of an ancillary probate of a piece of real estate in Arizona?
The cost is usually between $1,500 and $3,000, depending on how many different Arizona assets there are.
Okay. The other thing that came up as well is you mentioned the Arizona beneficiary deed. Is that really like a transfer on death deed?
It is.
Okay. I'm just, as an aside, have you folks seen any issue as far as insurance coverage for the beneficiaries of that deed being an issue for down the road?
I haven't seen an insurance coverage issue. I definitely see insurance issues if someone's not residing within the real estate. So if it's just like a vacant property that people are holding, it can be hard to get long-term insurance in that case.
Okay. Well, let's talk about non-residents. You know, many people, want to go to the sunny state of Arizona for the warm weather and the good climate. Okay, so and they've done documents like here in Virginia, wills, power of attorneys, revocable trusts, medical directives, HIPAA forms, all good stuff, which they're trying to keep their affairs in order. They show up in Arizona and they take up residence there. Now they have documents that we're good in Virginia, but it may or may not be good in Arizona. So let's talk about the first one, okay? Power of attorney, Virginia power of attorney. Should they get that updated under Arizona law?
They should, and this is actually the most important document I tell people they need to update, because if you become incapacitated, it's too late. But you can't take a document that's foreign looking and have someone here in Arizona accept it, even if legally you say it's still valid. If they don't recognize it, it doesn't do you any good.
Yeah, we advocate that very, very, very strongly. So the other document, the next one is all of the medical decision-making documents, you know, from HIPAA access to records to medical decision-makings about whether or not you want to live on and be kept alive on machines or not. What should they do about that document when they move to Arizona?
The same thing. I recommend that you update them. Number one, unlike banks, most medical institutions don't have a lawyer who reviews them. So if your actual medical provider doesn't recognize it as standard language, they won't take a look at it. But the second issue I actually see more is that Arizona requires these documents to be notarized, and a lot of states will permit it with only a witness signature, so they may be completely invalid in Arizona.
That's very true, and that is an issue across many states. Okay, some states require 3 witnesses as opposed to 2. So I think that's for viewers to understand whether they're moving to Arizona or any other state. They need to be very careful about those specific documents. The other document that comes into play is, of course, a will. Now, we see in Virginia that a lot of foreign wills can be used to probate assets here because they meet the requirements, even without having a self-proving affidavit. But tell me what the requirements are in Arizona. If I show up with a Virginia will that, how am I going to get that admitted to probate?
A Virginia will can be admitted to probate only if it's signed, the original signatures, has 2 witnesses and a notary. So 3 different people unrelated by blood or marriage.
So a spouse cannot witness their other spouses, children cannot witness. That's kind of and is that something that's been in the statute for years down there in Arizona?
It's more recent over the last couple of years, but this is leading people to really realize that they need to have things reviewed and updated over time.
Okay. So, that's important. And how about the self-proving affidavit? Is that something that's required?
100% required.
Okay, so we can't produce depositions of witnesses, in lieu of that?
I would say you can through the formal probate process, but initiating probate and getting to that point is going to be 9 to 12 months.
Okay.
It's not quick, and you cannot have the appointment of a personal representative during that intervening time frame.
Sure. Of course, in Virginia, we do have those forms we can use to at least get depositions. Okay, then the last thing would be is someone has done their homework and has created a revocable trust. They've done a lot of funding and pretty much put everything in the revocable trust, but it's under Virginia law. Okay, so now they take up residence in Arizona. They show up at your office or any lawyer's office down there and being asked to make a change to the trustees or successor trustees, or maybe the disposition plan because some child has made them angry, whatever it may be. Will an Arizona lawyer be able to really take that document and make those amendments?
It in part depends on what the amendment is, but it's very difficult. A lot of people move to Arizona for tax reasons. So we want to make sure that the trust reflects Arizona tax law so that you won't be taxed upon passing. So it can be difficult to make small changes when you're doing something as major as changing the governing law of a trust.
So then in that situation, then it's probably going to be a restatement of the document?
Right, we often have to do a restatement.
Explain what that is. Explain what that restatement means, though.
I would say the good news for people is we keep the same trust name and date, so you don't change the funding, but I sort of say you get all new paper, right? Expensive paper, but you're fully documenting the changes.
That's important. And there is no, apparently you mentioned the state tax, so there's no Arizona death tax, is that correct?
That is correct.
Is there any sort of beneficiary tax?
There is not.
No inheritance tax, okay.
Not at all.
Well, this has been very interesting. Let's Tell me a little bit about, as we get to this particular stage of the show, we always want to pick people's brains because, you know, we never can cover all the experiences they've collected over their years of practice. I know you have not been practicing that long, but certainly you have a lot of years of experience. Tell us a little bit about some of the lessons you've learned in dealing with ancillary probates over the years.
Ancillary probate itself is usually pretty easy. The most difficult thing is we still in Arizona require original signatures. So I need for the personal representative to sign it, notarize it, and mail it to me. And usually that accounts for the greatest time lag. But after that, Arizona is very fast. Our largest county, Maricopa County, usually processes our probate applications in less than a week. So you really can wrap things up quickly once you get an attorney and get started through the process.
Now, you've mentioned, though, that as you get into other outlying counties, that things may proceed a little more slowly. Is that true?
It is. Some of it's just rural, and so they're less staffed. We try to keep track. So my longest one was a 2-month ancillary probate where the clerk had just kept telling us it's on the desk, we're waiting for a signature. So we try to follow up, but it can take 2 months if needed.
Okay. Is there any other issues that in the ancillary probate process that you want to point out that we should be especially aware of based on some of your own experiences in the last few years?
So the other issue I see is if you do a small estate or a simplified probate in the home state, that is not sufficient for ancillary proceedings. So the ancillary proceeding in Arizona requires that you already have letters and a court order issued. If you don't have those and you just have something clerk approved, that will not let you go through the simplified ancillary proceeding process.
So at that point, even though I'm not a resident of Arizona, I will have to go through the formal probate process that you described in an earlier show. Is that correct?
That is correct.
Okay. Well, that's important. So we need that triple seal, typically, you know, with all the good stuff in there. So, and getting formally appointed. So good for people to know. Well, we're kind of reaching the point in our show where we want to get some final words of advice on steps to take, pitfalls to avoid, and all those different types of things that, you know, would create a roadblock to getting people, you know, through an ancillary probate in Arizona. Could you share those with us, please?
So I have one right now. And typically roadblocks are when there are more than one personal representative. So I have a case right now with 2 personal representatives, and they need to do the Arizona proceeding, and they disagree on the ultimate distribution of the process. So one of them is refusing to sign and notarize the paperwork, and we're really handicapped. There is nothing we can do at this point.
Well, that's interesting. So that really is, and is that an ancillary probate?
That is because the 2 of them were appointed in a prior court. Okay. So I can't now have only one of them do the ancillary proceeding. They have to do it together.
Even though if the document said that either one of them can act unilaterally, that would not work?
It does not work, unfortunately.
Wow. Well, Arizona is really strict.
It is strict. And it's cheaper than many places, and it's faster than many places, but you have to check the boxes very specifically because it's not flexible.
I think that really brings to point my final comments, which I'll get to in a second. But I wanted to take this time to thank you for taking the time to speak with us about ancillary probate. You know, this is obviously you're sharing a lot of great information, a lot of personal experiences, and some of the mishaps you've seen people undertake to do over the years, which is a great public service for folks who are viewing this show. Hopefully they'll learn from those lessons and remember that it's probably a good idea that they might want to talk with the Arizona attorney before they get started. But I want to thank you for taking the time to share with us.
Thank you so much for having me today.
You're very welcome. Without a doubt, probate can be complicated and confusing. Allison has given you an excellent introduction to the Arizona ancillary probate process, including steps to take and pitfalls to avoid. But I would be remiss if I did not note that there are legal documents to be drafted and filed even in an ancillary probate. So I encourage you to seek the advice of an Arizona probate attorney at the outset of your ancillary probate journey. Their guidance will help you avoid unnecessary work, delays, and additional fees and cost. This brings us to the conclusion of our show. Hope you found the show helpful. Replays can be viewed on the Probate Nation website and YouTube channel. And if you want to receive monthly probate tips, please sign up for the free Probate Nation newsletter at probatenationnews.com. Many thanks for tuning in. Until next time, I am Richard Ruddy, and this is the Probate Nation. Allison, what happens if, to a blended family, if one of the spouses dies without a will?
Blended families are my single most difficult type of probate client, and more than anything, really need a plan. If there is no plan, the deceased assets go 50% to the surviving spouse and 50% to the children of the other relationship, which in essence mean that the children you have with your current spouse can get nothing. And it often means the surviving spouse has to leave and sell the personal residence, and then only takes half the net proceeds to buy something new. People get upset, there are tears involved, and it creates a whole lot of hassle.
Allison, tell our viewers a little bit about what's the purpose behind executing a will, and what are some of the basic things the will should cover?
In Arizona, a will identifies who will manage your affairs and distribute your assets in the future. It also identifies who receives these assets. And if you have minor children, a will is the only document that can appoint a guardian for them if you pass. So if you have specific wishes, if you walk in my door and say it's complicated, you 100% need some sort of will.
Allison, let's talk a little bit about the execution requirements that are acceptable to probate a will in Arizona.
So Arizona requires 2 witnesses and a notary, so 3 separate people, unrelated by blood or marriage.
And if we have a will from another state, okay, will that will, even though it has 2 witnesses, will that will be acceptable in Arizona if we have not had a formal probate here in the other state?
It will not be accepted. So I 100% have clients who come from California, for example, who believe that their will is valid, and it is not. And a judge will say, Mrs. Kierman, I cannot accept this will, even though you want me to.
That is very, very frustrating. That is actually a huge pitfall for people that have property in Arizona, whether they are, if they have not fully funded everything in Arizona in the revocable trust. That is a huge issue. That's a very good point to bring up. Allison, what are some of the common mistakes that you see people make in attempting to probate an Arizona will?
Importantly, in Arizona, you need the original document. So the actual piece of paper the deceased signed, not a PDF copy, even if they handed it to you directly. So number 1, we need an original. Number 2, it has to be executed properly. So signed, witnessed, and notarized by unrelated, disinterested individuals.
So Allison, what is a community property agreement?
Arizona is a community property state, which means the underlying assumption is that the spouses own everything together, inherit 100% from each other, and only after both pass do other heirs inherit. When I have clients move here from other states, especially states that are not community property states, we often sign a community property agreement that solidifies that underlying assumption. But it also serves to add an exception if that is not the underlying assumption. So if, for example, you did intend for your children to inherit while your other spouse is alive, we need to write that down somewhere and codify it under Arizona law, not just in the original estate planning documents you executed.
Do couples in Arizona typically have separate trust?
They do not. Because Arizona is a community property state, we usually have one revocable family trust that governs all assets, even if some of the assets are treated differently. For example, if you wanted a family inheritance to skip your spouse, that would still go into the master family trust agreement. Some clients do have a his, a hers, and an ours trust. It becomes complicated from a funding perspective, but is actually very rare.